I looked at him for exactly 2 seconds. Then I cleared the entire courtroom. Not a recess. Not a brief pause to consult with my clerk. I stood up mid-hearing and told 40 people, the gallery, the press waiting for an unrelated case, 2 attorneys mid-sentence to leave the room immediately. Nobody argued with me. You don't argue with a judge who has just gone completely still. I want to tell you what I saw in those 2 seconds. But first, I need you to understand something. By the time you finish this video, you are going to know exactly why I did what I did, and you are going to understand why this case never appeared in any news outlet, why no reporter ever wrote about it, and why I am only telling you now. Here's where it started. The case was supposed to be simple, a property dispute. A man named Curtis Relm was suing his elderly neighbor over a fence line that had apparently shifted 3 inches onto his property sometime over the previous decade. The kind of case I handle 6 times a week without anything unusual happening. The kind of case where both parties are mostly tired of arguing about something that, deep down, neither of them actually cares about as much as the principle of the thing. Curtis Relm walked in at 9 o'clock sharp. He was calm, polite, dressed in a gray sweater, the kind a grandfather wears, the kind that signals nothing alarming whatsoever. Mid-50s, average build, the sort of unremarkable presence that doesn't draw a second glance in a grocery store or a courthouse hallway. He shook his attorney's hand before sitting down. He nodded politely at my clerk. Everything about him said ordinary. His attorney did the talking. Curtis barely spoke, which on its own means nothing. Plenty of plaintiffs let their attorneys carry the procedural weight while they sit quietly. I noted it, the way I note everything, and moved on without thinking twice. For the first 11 minutes, this looked like nothing. The attorney walked through the property survey. He referenced the original deed from 1987. He mentioned a previous informal agreement between Curtis and the prior homeowner that had apparently never been formalized. Standard fence line testimony. The kind of case where I'm already mentally drafting the ruling before the hearing is even halfway done, because these disputes resolve themselves on documentation almost every time. Then his neighbor, an 81-year-old woman named Edith Sorrell, took the stand to testify about the fence. She was exactly what you'd picture. Silver hair, careful posture, the kind of measured voice that comes from decades of being patient with people. She had lived in that house for 31 years. She described the fence's history calmly, factually, the way someone describes something they've genuinely thought through and aren't trying to win through emotion. And as she started speaking, Curtis Relm turned his head to look at her. That's it. That's the whole action. A man turned his head, maybe 4 inches, to look at a woman testifying against him in a routine civil matter. I have seen 10,000 people turn their heads in my courtroom. People look at witnesses constantly, out of curiosity, irritation, boredom, the simple human instinct to watch whoever is talking. I have never seen anything like what I saw in his eyes in that single turn. I'm not going to describe it the way you're expecting. This isn't a story about a scary face or a menacing glare. If I told you it was just an intense look, you'd close this video and move on, and you'd be missing the actual reason this case changed everything in my courtroom for the next 18 months. What I saw was recognition, not Curtis Relm recognizing Edith Sorrell. They'd been neighbors for 6 years. Of course he recognized her. That part is obvious and means nothing on its own. I saw something else entirely, a fraction of a second of complete frozen stillness in a face that had been animated and ordinary right up until that exact moment. The specific kind of stillness that happens when someone's body executes a reflex their training spent years trying to erase, and almost succeeds, except for the 1/10 of a second before the conscious mind catches up and corrects the expression back to neutral. I have sat on this bench for 4 decades. In that time, I have learned to read faces the way some people read weather patterns. Not because I set out to develop the skill, but because 40 years of watching thousands of human expressions under pressure teaches you patterns you cannot unlearn afterward, whether you want them or not. There is a particular stillness that exists in exactly one population of people I have encountered across my career. And I want to be precise about this because it matters enormously to everything that happened next. Not nervous defendants, not guilty people caught lying, not even hardened criminals who've been through this system many times before. Those people have their own recognizable tells, and I know all of them by now. This was different. This was the stillness of someone whose nervous system had been specifically trained, deliberately and extensively, to suppress exactly this kind of reaction, and who had, for one fraction of a second, failed to suppress it completely before catching themselves. Former intelligence operatives carry this stillness. I learned to recognize it decades ago, under circumstances I am not going to detail in this video, circumstances connected to two entirely separate cases earlier in my career that had nothing to do with fences or neighbors. And I had seen that exact stillness only twice before in my life. Both times, federal agents showed up within the hour of my recognizing it. So I stopped the trial. I did not deliberate. I did not weigh the disruption against the cost of being wrong. I have learned, over 40 years, that when this particular pattern recognition activates, hesitation costs more than acting on it ever has. I said 5 words. Everyone out, right now. My bailiff didn't ask why. 40 years of working together means he trusts my instincts the same way I trust his reflexes, the same way a surgical team trusts the lead surgeon's sudden change in plan mid-procedure without requiring a full explanation first. He cleared the gallery in under 90 seconds, moving people out with the calm efficiency of someone who has done crowd control before and knows that calm efficiency is what prevents panic from spreading. Edith Sorrell was confused, gathering her things slowly, looking back at me with the expression of someone trying to figure out if she had done something wrong. She hadn't. I made eye contact with her briefly and gave her the smallest possible reassuring nod, though I couldn't explain anything yet. Curtis Relm's attorney was furious, already drafting a complaint in his head about judicial overreach, already calculating what grounds he might have for some kind of formal objection once this was over. I understood his frustration. From where he was standing, his routine fence line case had just been derailed for no visible reason. I didn't care about his frustration in that moment. There are decisions in this job where you accept that you will look unreasonable for several minutes in exchange for being right about something that matters more than anyone's immediate comfort. Once the room was empty, just myself, my clerk, my bailiff, and the 2 parties separated into different rooms, I asked my clerk to do one specific thing: pull Curtis Relm's full legal name, date of birth, and submit a discrete query to a federal database that civil court judges almost never have any legitimate reason to access, and that exists specifically for situations exactly like the one I suspected I was looking at. It came back in 4 minutes. 4 minutes that felt considerably longer, standing in my own chambers, genuinely uncertain whether I had just disrupted a man's entire Tuesday over an overactive imagination that might, this one time, simply be wrong. It was not wrong. And what came back is the part of this story that until right now, exactly 6 people have ever known. Curtis Relm was not Curtis Relm's real name. His legal name, the one on file with federal witness protection, was Daniel Voss, no relation to any attorney named Voss you may have heard of in any other case. This is simply the most common surname I encounter in this particular city, and I have genuinely stopped being surprised by it. Daniel Voss had testified 14 years earlier against a cartel logistics operation responsible for trafficking that spanned 6 states. He had been a mid-level operative inside that organization, recruited young and in over his head before he fully understood what he'd gotten into. And he had eventually approached federal investigators voluntarily, a decision that, according to the file, had likely saved his own life by getting ahead of an internal purge that ultimately claimed 2 other people in his exact position who had not come forward in time. His testimony had put 3 men in federal prison for life. The prosecution had described his cooperation in sealed sentencing documents I would later be permitted limited access to as the single most critical piece of evidence in dismantling an operation that had run undetected for nearly a decade. In exchange, the government had relocated him, renamed him, rebuilt his entire identity from the ground up. New Social Security number, new employment history, new everything, and placed him in witness protection with one explicit, repeatedly emphasized condition: avoid anything that could draw public attention, anything that could put his name, his face, or his location into any kind of public record that someone with the right motivation and the right resources might eventually search. A civil lawsuit over a fence line is exactly the kind of public record that condition exists to prevent. It is mundane. It is exactly the sort of thing nobody thinks to consider dangerous, because on its surface it has nothing to do with anyone's old life. That is precisely why it is dangerous. His own attorney, hired locally, entirely unaware of any of this, hired specifically because Daniel Voss could not risk using any of the federal resources connected to his original case for something as ordinary as a property dispute, had filed a case that put Curtis Relm's name, his address, and supporting documentation directly into a public county filing system. Standard procedure, completely correct legal practice, filed exactly the way